entity. Management of the corporate entity is a bit different than your management of your typical business entities because, as we remember, the benefits of investing in a corporation are limited liability and also hands-off ownership. So I buy a share of stock and I don't really have to worry about the day-to-day management of the company. The board of directors manages the business affairs of a corporation and they're elected by the shareholders. So as a shareholder, I get a vote. I get generally one vote per share of stock, and so I get to vote to elect the members of the board of directors. Those boards of directors hire the top level managers who then run the day-to-day operations of the company. These are officers. They have the authority of general agents for the operation of the normal business of the corporation. This is your CEO, your presidents, your VPs, your secretaries, your treasurers, your CFO, your COO, all of those high-level officers. The shareholders are the ultimate owners of the corporation, and the more shares a shareholder owns, the more voting power the shareholder has in the running of the corporation. And generally, people who own very few shares don't vote. They are allowed to vote, but they don't often vote for boards of directors. Stakeholders are people who may not be an owner. They're not officially part of the corporate decision-making structure, but they are affected by the results of the corporation's decisions. This might be representatives from employees' unions, consumer protection organizations, suppliers, customers, clients, environmental groups, local, state, national, and international communities. And so there are different theories about governance of a corporation and how much corporations should pay attention to these outside stakeholders who aren't really involved in the ownership or decision-making of the corporation. The first is governmental control, and this is based on the belief that because corporate decision-making influences more individuals and more groups than just the shareholders and the managers, corporate decisions should be made by an impartial group of corporate outsiders. So usually these outsiders are governmental officials. They're specially educated and they would make corporate decisions in an objective manner based on the needs of the entire society and the economy as a whole. So opponents of this theory say that such an approach is socialism. It's socialistic, and they point out the relatively poor track record of many socialist economies as evidence of the impracticality of this approach. There's the independent director control theory, and it says that it's the most effective way to ensure that corporate decisions are made in the best interest of those affected is to make certain that the decision makers themselves are not affected by those decisions. All right. Also, independent directors are directors who have no family members employed by the corporation, who are not themselves employed by the corporation, or if they were at one time employed by the corporation, they haven't been on staff for at least 3 years. And also a controlled company is one that has more than half its voting power concentrated in one individual or a small group of people who always vote together. Managerial control theory says the officers and directors of a corporation are in the best position for judging not only the needs of the corporation, but also the needs of the community and the needs of society at large. Individuals who favor this kind of control would insulate the managers from shareholders by limiting the shareholders' power to vote and making it difficult for shareholders to sue managers. Opponents of this type of control say that corporate managers may tend to be self-interested, so they may do things that only benefit themselves, and as a result make relatively short-sighted decisions. Stakeholder control is based on the idea that corporate decision-making affects more individuals and groups than just the shareholders and the managers of the corporation, and then that they should therefore have a pretty big voice in corporate decision-making. Shareholder democracy states that shareholders have the right to run the corporation because without their money, the corporation would not be able to survive. This is also known as corporate democracy. And it says basically, of course, they have a right to say how their money should be spent and their property should be used. Supporters of this theory would make management more responsive to shareholders by giving shareholders greater voting control and making it easier for them to take managers to court. Opponents of this theory point out that most shareholders are removed from the center of corporate activity and therefore can't really make the same type of informed decisions the managers can make. So shareholders do have a lot of control in managing the corporation, even though they don't really do a lot in the day-to-day management, but they do have control in voting and they can bring lawsuits. So we will talk about each of these in the next few slides. So when they vote, they can use what's called cumulative voting, which is a system that allows shareholders to multiply the number of their voting shares by the number of directors to be elected. And it allows minority shares an opportunity to be represented on the board of directors. So how this works is if I own 5 shares, right, or let's just say I own 1 share. Say I own 1 share, and we're electing 4 directors. So rather than casting 1 vote for each director spot, cumulative voting gives me 4 total votes, and I can apply all those votes to just 1 board of directors spot. So it kind of magnifies my power, even though I only own 1 share. So I can choose how to cast those votes. I can cast them all for 1 candidate, or I can distribute them among many candidates. There's also what's called proxy solicitation, which is the process by which one shareholder asks another for his or her voting rights. So if you own a minority share in some company, you may get these in the mail. It's the authority given to one shareholder to cast another shareholder's votes. So somebody is trying to get a whole bunch of votes to basically make waves in the board of directors election. Proxy solicitation also refers to the actual document that's used to request the right to vote the other shareholders' votes. The minority shareholders' voting power increases as the number of proxies held rises. Because majority shareholders, including management, can also solicit proxies, sometimes there's a struggle between those two groups. That is known as a proxy contest. A shareholder proposal is a suggestion about a broad company policy or procedure that's submitted by the shareholders or by a shareholder, and it must concern something that affects all shareholders. This is another way for shareholders to exercise their voting power. Because shareholder proposals are placed in the proxy materials that are sent from corporate management to shareholders, they're closely allied with the proxy solicitation process, and it's heavily regulated by the Securities and Exchange Commission. Another way that shareholders try to affect voting is by a voting trust, which is an agreement among shareholders to transfer their voting rights to a trustee, and then they all vote the same. So it magnifies voting power. A trustee is a person who's entrusted with the management and control of another's property or the rights associated with that property. So the person who agrees to serve as trustee agrees to serve in the manner that all of the shareholders have asked said person to serve. So they're voting the way that they're told to vote. Shareholders also sometimes execute pooling agreements. That's when shareholders join together in a temporary arrangement and agree to vote the same way on a particular issue. But they do retain control of their own votes. So sometimes shareholders might join in a temporary agreement and agree to vote the same way on a particular issue. But they retain control of their own votes, meaning they can change them. It's not giving their right to vote to someone else. Shareholders can also sue when they believe that the board of directors has acted inappropriately. There's 2 basic ways: a direct suit and a derivative suit. In a direct suit, it's brought by the shareholders who've been deprived of a right that belongs to them as shareholders. So I sue in my own capacity for my own right. A derivative suit is going to allow shareholders to sue corporate management on behalf of the corporation. So instead of suing individually, instead of John Smith suing the corporation, it would be the corporation suing the corporate management because they have acted inappropriately. To do these things, we have what's called a rule of contemporary ownership, which requires a shareholder to own stock at the time of the injury and at the time of the lawsuit to bring the lawsuit. All right, the rights we might sue for violation are maybe the right to vote, the right to receive dividends, the right to transfer shares, the right to purchase newly issued stock, and the right to examine corporate books and records. So if shareholders have been denied any of those rights, they can bring a direct suit to make up for any losses they've suffered. Management must act appropriately when managing a corporation because they're acting on behalf of shareholders. And there are some rules that apply: the business judgment rule, the fairness rule, and the actual authority rule. And so on the left, you can see when these rules apply, and on the right, you can see what the rule is. So if a business manager does not profit from a decision, you would use the business judgment rule. If a business manager profits from a decision, you'd use the fairness rule. What we mean by profit is, say that a business manager has another business on the side and the corporation needs a supplier of tractors. They need to buy a new tractor. Well, the business manager also maybe owns a tractor dealership. If the business manager negotiates a deal with his dealership and the corporation he manages, that business manager would profit from that decision, and we would use the fairness rule. The fairness rule says that the decision must be fair to the corporation because managers must remain loyal to the corporation. So the fairness rule doesn't prohibit that. It doesn't prohibit a business manager from profiting from a decision. But what it does prohibit is a business manager profiting from a decision that is bad for the corporation. If the business manager does not profit from a decision, we use the business judgment rule. And that says the decision stands if it was made in good faith, with due care, within the law, and it was in the corporation's best interest. And we'll talk about that a little bit more on the next slide. And then if the business manager exceeds his or her authority, we use the actual authority rule. And the actual authority rule says a manager may be held liable if a corporate decision maker exceeds corporate authority and harms the corporation. So first, the business judgment rule results from common sense belief that based on their education, experience, and knowledge, managers are in the best position to run the corporation. Under this rule, a court will not interfere with most business decisions. That rule is going to protect managers who act with due care and in good faith as long as their decisions are lawful and in the best interest of the corporation. So courts kind of defer to the business managers under the business judgment rule. The duty of due diligence requires that a business manager, when acting on behalf of the corporation, acts legally, in good faith, using the same level of care that an ordinarily prudent individual would use in a comparable situation, and in the reasonable belief that the best interests of the company are being met. So protecting directors and officers in this way encourages people to become corporate managers and reassures them that they will be protected when they make difficult decisions. The business judgment rule emerges from the duty of due diligence that a manager owes to a corporation. The fairness rule requires managers to be fair to the corporation when they personally benefit from their business decisions. This is the one that we talked about, the tractor company, right? They need to buy tractors and the business manager has a tractor dealership. This is the rule that would apply. There's also the insider trading rule, which comes from the SEC, the Securities and Exchange Commission. When managers possess important inside information, they're obligated to reveal that information before trading on it themselves. So this is the Martha Stewart rule, right? Remember, she went to jail and she went to jail for insider trading. When inside information is revealed, the managers must use that information when trading with the corporation or with those outside the corporation. And the SEC identifies the following classes of individuals who might be at risk of finding themselves on the wrong side of an insider trading case. So this might be corporate directors, officers, and employees, because they have access to insider corporate information, right? Things that the public doesn't know. And if they do use these material, non-public, factual data in their trades, they're at risk for running afoul to the insider trading rule. This also might apply to their family members, colleagues, or friends because they might communicate that information to them. The corporate opportunity doctrine says that corporate managers can't take a corporate business opportunity for themselves if they know that the corporation would be interested in that opportunity as well. So if, going back to this business manager who has another business on the side, If an opportunity to enter into a really nice, lucrative contract presents itself, that business manager must offer it to the corporation first before acting on it by herself. The actual authority rule states that a manager may be held liable if he or she exceeds his or her authority and the corporation is harmed as a result. So this means that the business manager must act within the powers that have been granted to him or her by virtue of the position within the corporation. The duties of the directors and officers of the corporation are outlined in the appropriate state statutes, in the articles of incorporation, in the regulations issued by government bodies such as the SEC, in relevant case law, and in the bylaws of the company. And if they exceed that authority, they can be subject to lawsuit. There are some efforts to limit liability. One is voluntary protective measures. That's going to be one that permits corporate shareholders to fashion their bylaws so as to limit or eliminate the liability of directors for decisions made while carrying out their duties. That would allow recovery of damages only if the director deliberately breaks the law, deliberately violates the duty of loyalty, deliberately violates the duty of good faith, or improperly benefits from the transaction in question. There's also been efforts to increase responsibility. One of those is the Sarbanes-Oxley Act, and it places an affirmative duty on the directors of publicly traded corporations to monitor whether their corporation is conforming to all legal requirements. So this is kind of a relatively new act. Corporate directors, legal commentators have suggested now that corporate directors should take the following steps when they're faced with suspected wrongdoing within their company. So it's 7 steps once there's either something illegal has happened or they suspect it may have happened. So first, once a legal violation has been uncovered, the activity must cease instantly. 2, any and all consequences that have flowed from the violation should be uncovered and stopped immediately. 3, any attempt to engage in a cover-up, and in fact any actions that can be remotely perceived as a cover-up, must be avoided. 4, notification of the violation must be made to the proper authorities. 5, investigations must be made to uncover any similar or related activities that may be illegal. 6, the cause or causes of the legal violations must be determined. And 7, an action plan must be created and executed to punish the violators and to prevent any future violations. The United States Sentencing Commission issued a set of rules that control the discretion of the federal courts in issuing fines against corporations found guilty of criminal activities. So they have to sentence and issue those fines in a prescribed way now. So they only have a small range of fines and a small range of punishments, whereas before they had more discretion to make the punishment smaller or make it larger. The shareholders also have some rights. They have the right to examine corporate records. They have the right to share in dividends. They have the right to transfer shares of stock. And they often have preemptive rights. And preemptive rights are the shareholders' right to purchase a proportionate share of every new offering of stock by the corporation unless the right is denied or limited by the corporate charter or by state law. So we've discussed this one before, but this gives shareholders the right to keep their proportional ownership of the corporation. If they own 20% and a corporation decides to issue new shares, they are allowed to purchase as many shares as they need to keep that 20% ownership.